Welcome to S.T.I.R Talk again, and thanks everybody for coming early. All of you are good, observant email readers, apparently, because we're starting 5 minutes early, and congratulations on being here. Remember to not throw your bottles away in garbage can. We want to recycle them. Are there recycle receptacles around? Look for them, okay? So it's with great pleasure that today we introduce Rick Duncan, Professor Richard Duncan. God, formal. He's dressed up. This is the most dressed up that I've seen him in the 30 or so years that I've known him. So I want you to really appreciate the fact that he's got a jacket on and a shirt with a collar.
Socks.
And socks. This is incredible. Professor, and it's kind of strange introducing him from everybody's reaction. He's really one of the professors that needs no introduction. But I will give you a couple of little tidbits. As you all know, he teaches property law and constitutional law. And he's not shy about his politics, never has been. When I first met him back in 1986, it was, I just have this image of him in the dead of winter, January, February, wearing a T-shirt with Ollie North or Ronald Reagan on the front. He's a weight lifter, and so the T-shirt was nice and tight and showed everything off. Lately he's been in demand at Federalist Society chapters all over the country. Hard to keep him up. We can do a Where's Duncan game, finding out which school he's going to be addressing lately. But one of the things that you might not know, unless you visit his office and catch him right at the right time, he's an avid Bob Dylan fan. He's got, and I am too, and I consider myself a pretty strong collector, but it's nothing compared to Professor Duncan's collection, including bootlegs. I mean, he showed me how to amass a collection of bootlegs. He's got them all. So at heart, I want you all to know Professor Duncan really is an outlaw, okay? So he's going to be talking to us today, Originalism versus the living Constitution. What if both are correct? And the answer to that question, my friend, I'll quote his musical hero, is probably blowing in the wind. Professor Duncan.
Well, thank you, Rich, for that introduction. I have a very small bucket list. I'm not a bucket list kind of person. I tend to live for the moment. But there are probably two things on my bucket list. And one of them I get to do this year is part of my speaking tour. I spoke at Northeastern, and I get to sit up in the monster seats at Fenway Park in a year when the Red Sox, as though it doesn't happen all the time, won the World Series once again. So that was one thing on my bucket list, was to sit up on the green monster. And the other one is to bench press 300. And I'm not quite there yet. I'm not that far away, though. For a guy my age, I'm pretty darn close. So this is the 15-minute or two-beer version of what is normally a 40-minute talk. So I had to cut out most of the good stuff to get it down to a 15-minute presentation. But since we've got beer, who cares, right? So the title of this talk is Originalism versus the Living Constitution. What if both are correct? Now there's a novel idea to suggest that maybe both sides of a debate have reasonable positions. So let's talk about this great debate in constitutional law. The great debate in constitutional law, one that has raged for over 200 years, going all the way back to Calder versus Bull in 1798, and most recently surfaced in the healthcare decision, is this: should courts interpret the Constitution's text as it would have been understood by ordinary citizens alive at the time the text was adopted, Or should the judges interpret the Constitution as a living organism, one meant to evolve to suit the changing needs and values of contemporary American society? Now, originalists believe that if the Constitution must evolve to keep pace with our constantly changing world, we should seek this change through the legitimate amendment process of Article 5. Simply put, amendments should come from the people, not the Supreme Court. However, proponents of a living Constitution believe that the formal amendment process is too cumbersome, that it's too difficult to amend the Constitution through the procedures of Article 5 to keep the Constitution current, and that therefore necessity requires the Supreme Court to step up to the plate and amend the Constitution from the bench. For example, if the Written Commerce Clause does not give Congress sufficient power to deal with a global economy and contemporary problems such as the healthcare crisis, then it's the duty of the court to recognize that the Constitution has somehow evolved to meet our ever-changing political needs. After all, why should contemporary Americans be saddled with the views and philosophies of long-dead white males who had no understanding of the needs and values of America in 2013? Now, for what it's worth, notice that the majority of the Supreme Court in District of Columbia versus Heller, the court's recent Second Amendment decision, appears to adopt original understanding as the proper method of constitutional interpretation. Here's what the majority said in Heller. So, at least in theory, this is the law of the land. Says the court, in interpreting this text, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrases were used in their normal and ordinary as distinguished from technical meaning. In other words, the interpretation to be searched for is the meaning that would have been understood, again, the court's words, by ordinary citizens in the founding generation. Well, perhaps both sides of the great debate are correct, at least an important part. Originalists are surely correct when they point out that judicial amendments to a written Constitution are illegitimate and tyrannical. After all, the Constitution should reflect the values of we the people, not those of the Supreme Court. As one commentator has put it so well, how can we have rule of law when judges can amend the Constitution at their whim? But it seems equally true that we need a living Constitution, one that reflects the political needs and values of we the people alive today. And it is also true that the existing amendment process under Article 5 that requires, before a constitutional amendment can even be proposed for ratification, a 2/3 vote in the House and a 2/3 vote in the Senate. How easy is that? Particularly with anything controversial, particularly with anything that would limit the power of Congress. It's almost impossible to amend the Constitution under Article 5, so living constitutionalists are correct when they say it's cumbersome, to say the least. As Dean Chemerinsky explains, the court must reject originalism if the Constitution is to meet the needs of a changing society. But the question that haunts me is the normative who question. Who should have the power to shape the living Constitution? The people through the amendment process, or the court by interpretation? If the court is not bound by the original meaning of the text of the written Constitution, where does the court look to discover the new values and liberties and principles contained in the living Constitution? As the late, great Judge Bork once put it so well, the hard fact is, however, that there are no guidelines outside the Constitution that can control a judge once he abandons the lawyer's task of interpretation. There may be a natural law, but we are not agreed upon what it is. And there is no such law that gives definite answers to a judge trying to decide a case. The truth, says Bork, is the judge who looks outside the Constitution always looks inside himself and nowhere else. Now, although proponents of the living Constitution speak of the Constitution evolving by interpretation, surely the sudden appearance of new constitutional rules in the fossil record of the living Constitution is best explained by a theory of creation, not evolution. In other words, changes in the living Constitution are called into being, are created by Supreme Court opinions. They do not evolve over billions of years by means of some impersonal process of natural selection. On this issue, if we are honest, we are all creationists. The image of an evolving Constitution is just a fig leaf designed to cover the naked fact that new constitutional rights and doctrines are being created by a body of unelected lawyers, to quote President Obama as he wagged his finger at the Supreme Court when he thought it was about to strike down Obamacare. So it is creation, not evolution. Recently, Georgetown law professor Louis Seidman, in a New York Times article, Google this one, entitled, "Let's Give Up on the Constitution," admits that much of the court's living constitutional jurisprudence amounts to what he calls constitutional disobedience. And he goes on to celebrate what he calls the court's flagrant disregard of the Constitution to reach results that he believes helps us to grow and prosper. Sounds a little bit like Mr. Spock. Is this really what we want? A court praised for its flagrant disregard of the Constitution? But at least Professor Seidman is honest and admits that the court is disobeying the Constitution. But suppose we need new constitutional rules to meet the needs of contemporary society. Don't we need to give the court, I mean, after all, Jefferson only had an Apple IV phone. He didn't have an Apple IVs phone. Don't we need to give the court the power to recognize new constitutional rules to deal with contemporary problems requiring constitutional solutions? Well, which new constitutional rules? A balanced budget requirement? We'll have one. 17 trillion, 25 trillion, 50 trillion, 100 trillion. At some point, we'll have a balance, but you have to take the credit card away from the teenager. Same-sex marriage, limits on the power of Congress to tax us excessively, term limits on Congress and perhaps on the court. Which new constitutional rules do we need in contemporary America? And again, do you trust the court to decide which new constitutional rules we need and which we don't? So, where do we go from here? Both sides have a good point. Where do we go from here with originalism versus the living Constitution? Well, here's the problem as I see it. The good of originalism and the good of living constitutionalism are mutually inconsistent. We must choose one or the other. We can't have both. If we choose originalism, the court can't create new constitutional rules to meet the needs of contemporary society. But if we permit the court to create a living constitution, we allow the court to rule rather than we the people. I think we need to make it easier for the people to create a constitution for our times and circumstances. We need a living constitution created by the people, not one created by the Supreme Court. However, since it's almost impossible for the people to amend the Constitution under Article 5 as it presently exists, what we need is a means of preserving both the original meaning of the Constitution while at the same time providing a workable process to keeping this original Constitution alive and open to change. What we need to do is to amend the Constitution and make it easier for the people to amend the Constitution and more difficult for the court to do so. And that's where this little handout comes in. And if this were something where we could have Q&A, we could have a really interesting conversation about this. But let me kind of lay out my proposal for you. If I were around at the time of the original Constitution, if James Madison had come up to me and said, "Duncan, help me out here, I'm having a hard time drafting Article 5, I would have said, "Jimmy, let me give you a few ideas." And these are what the ideas would have been. First, I would have anticipated the court's power grab in Marbury versus Madison. Judicial review is not contained in the Constitution. That's why we have this great debate, because the Constitution doesn't say the court shall interpret the Constitution in light of original understanding, or the court can do whatever it wants to do in light of the living Constitution. It doesn't say anything about judicial review. The court grabbed that power in Marbury versus Madison. And so the first section of this new amended version of Article 5, it's been a great debate for 200 years, but it's time to declare a winner. Ladies and gentlemen, your new American idol, originalism. Section 1, the words and phrases of this Constitution shall be interpreted according to their ordinary meaning at the time of their enactment, which meaning shall remain the same until changed pursuant to Article 5. The court will be instructed to follow what the court said was the law anyway in Heller. The court will be instructed to follow original understanding, originalism. So we just made it harder for the court to amend the Constitution. But we need to make it easier for the people to amend the Constitution. And that's what Section 2 and 3 of this proposal do. Section 2, instead of requiring a 2/3 vote in the House and a 2/3 vote in the Senate before we can even talk about a new constitutional proposal, why not allow a majority of either house, a simple majority of either house, to propose an amendment? So if Boehner and a majority in the House wanted to propose a balanced budget amendment, let them do it. And if Speaker Reed and a majority in the Senate wanted to propose a same-sex marriage proposal, let them do it. We can have a national conversation about it, and then if 3/4 of the states agree with Boehner, we'll have a balanced budget amendment. If 3/4 of the states agree with Reed, we'll have a same-sex marriage amendment. We'll live with the results in the states in the ratification process. But make it easier for the people to talk about amending the Constitution. And by the same token, Section 3 basically says, you know what, the state should have a direct avenue to amend the Constitution as well, or at least to propose an amendment. And basically Section 3 says whenever 10% of the states, whenever the legislatures of any 5 of the several states want to propose an amendment to the Constitution, let's let them propose the amendment to the Constitution. Again, it still requires a 3/4 ratification vote of the states to make that proposal part of the Constitution. But at least we'll be able to have a conversation about amending the Constitution. If the people think we need change, if the people think that contemporary values and problems require a constitutional amendment, they'll be free to do so. And we'll make it easier to get this before the people, to have a constitutional convention. Now, some people say it's risky to put the people back in charge of deciding what the Constitution should mean, that we really need robed lawyers who are all graduates of Harvard and Yale, except for Justice Ginsburg, who went to Columbia. We really need people who are smarter than us to decide what the Constitution should be and what it doesn't be. But I trust the people more than I trust the court, particularly more than I trust a 5-4 vote on the court. And I think it will make our politics better. Imagine if our politics consisted of talking about what the Constitution should say, about how we should be governed, about whether we should have a balanced budget amendment, about whether we should have a same-sex marriage amendment, recognizing that we the people are in command. It's not up to the court to amend the Constitution. It's up to us to do so. Rather than talking about whether one guy puts his dog on top of his car or the other guy eats his dog, we could actually be talking about something important. We could actually be talking about how we are governed, what the Constitution should say in contemporary American politics. I trust the people. I don't know where my time is. How are we doing here? Minute and a half. Well, good. I trust the people a lot more than I trust the court to make these basic decisions. And I do think we need constitutional change. My list of constitutional amendments may not be the same as yours. And what I'd like to do is, rather than allow us a 5-4 majority on the court to decide whether my list gets enacted or whether your list gets enacted, I'd rather make it easier to get these proposals before the court, before the people, rather. And some people say a majority in either house, that makes it, we'll have too many proposals. Well, how many amendments do we have right now? The Supreme Court probably amends the Constitution 20 times a term. It's simply by proposing and ratifying by a vote of 5 unelected justices, the Supreme Court changes constitutional doctrine by a vote of 5-4. So it's not the number of amendments that matters, it's the source. Where do the amendments come from? Do they come from we the people? Let's make it easier. My proposal is, let's make it easier for the people to amend the Constitution and more difficult for the court to do so. And that's what I would. Thank you. That's what I would have told Madison.